Good evening, everybody. And this evening we're joined by Mark McKone Counsel, who is a criminal barrister from Park Square Barristers in the northeast. And I know that Park Square Barristers Chambers have chambers in Middlesbrough, Teesside, Newcastle, and Leeds. Is that correct?
It is, yes. Originally Leeds. Then we merged with the chambers in Teesside. Now we've opened up an office in Newcastle as well.
Fab. And I've heard a lot about Park Square being quite leading for criminal work, a lot of criminal defence work. I know you do a lot of prosecution also, and you predominantly do a lot of serious violent cases, so murder, and a lot of the murder trials that you do are usually complicated with joint enterprise issues, which is a legal doctrine where if you can't, a lot of people can be prosecuted and found guilty of the same crime if they've been there or if they've assisted. And we're going to talk about joint enterprise this evening because
yes, of course,
interest in that as well. And you are also a Class 2 Crown Court judge, sort of recorder, because you still are a barrister as well. So what does Class 2 mean, if you don't mind me asking?
Most recorders are Class 2. You don't get it automatically, but it's quite easy to achieve. Class 2 cases are rape and serious sexual offences, so it means that you are allowed to try those. Part-time judge would never be allowed to try Class 1 cases, which are murder and similar cases, I think, including attempted murder. So really, Class 2 is as far as a recorder could go.
And do you hope to become a judge, if you don't mind me asking?
I've got a fairly settled position that I will never apply to be a full-time judge. I don't want to leave the bar. I think if I wanted to leave the bar, I would have applied before now. So I think my plan is to keep prosecuting, defending, and sitting. So it's like 3 different jobs, and we've got 10 different courts on circuit. So some ways it's like 30 different jobs. So I don't really want to go to the same place every day and perform the same role every day. But it could change. But I don't think so. I don't think I will ever apply. And I'm quite keen not to have to fill in another form.
Absolutely. And you are a King's Counsel as well, so a KC. So what made you want to take Silk, and when did you feel like it was the time in your career to go and do a Silk application?
I always thought that I would never apply, and because I did apply late, I think, by modern standards. Really, I was happy with the work I was doing, which was mainly rape trials, prosecuting and defending. I'm not sure, just one day I decided I would like to apply for QC as it was in those days, really to have a different type of work and really a new start and a new challenge. And I'm really glad I did it, because I feel as if I can keep going for many years and still enjoy it.
Absolutely. So as well as doing murder cases, and you also do some serious sex cases as well. In terms of then, on both outlooks, you being a recorder and trying those cases, and also being a barrister and prosecuting and defending those cases, I've often had discussions with judges and barristers who've ended up doing a lot of those cases, and that's why they moved to the judiciary, because they didn't want to do those cases anymore as a barrister. How do you feel about having? I mean, you've got the beauty of having the mix up of not the beauty, but the murder as well. But does it ever take an emotional toll on you?
I don't think so. I think I've been fortunate that I've not been emotionally affected by the cases. I don't lose sight of the fact that every case has had an emotional impact on both sides and will do forever. So people's lives are at stake. But I've always thought it's better for them if I'm emotionally detached from it. That's not to say that some cases are not harder than others. I think if a child's been harmed, that's a lot harder for the barristers to deal with than if adults have been harmed. But there's still that aspect. But definitely a lot of my colleagues want to leave the bar because they're fed up of doing rape and serious sex trials all the time. There isn't the variety. They take a lot of preparation because a lot of video interviews need editing, and that they have to fit in cross-examination of complainants in advance of the trial. I know a lot of people have decided they want to stop that. So some have applied to be judges. Some people have applied to come off the rape prosecution panel so that they're not eligible anymore for those cases.
In terms of any advice that you give, in terms of any advice that you give then to those people who come to you saying, you know, I'm fed up of doing these type of cases, how would you advise them to move on and progress as a barrister, like how you have, where you're doing now the murder cases and things like that? Do you just feel like that was your expertise and you had a special skill that equipped you to be able to do murder trials, or do you think it's because you branched yourself out to have that type of exposure to murder trials?
I don't think there was any game plan in particular. It's just that once you are a KC, you can do murder trials, whereas I wouldn't really have been doing them until I'd got those letters. Equally, now there are not many rape trials where the Legal Aid Board or CPS would pay for me to do those trials, unless it's a complicated grooming case with 40 defendants or so. So I think the reality is I've become ineligible for many rape cases now and eligible for the murder cases. So that's just how the system is. I'd be only too happy to be doing more rape cases, but it's quite rare for the funding to be made available.
Absolutely, thank you. That's an interesting point. I didn't really ever think of it like that, but obviously, of course, being a silk, you probably, well, you will cost more, rightly so. But in terms of then so we'll get onto the murder and the joint enterprise in a second. But in terms of your other position, the North Eastern Circuit representative for Lincoln's Inn, can you just talk to us a little bit about what that role is and how you also fit it in, given the 3 jobs that you've got, which is the 30 jobs, as we've just said?
Well, there isn't a lot of work involved in that. There are some online committee meetings. I managed to set up a dinner in Leeds for members of Lincoln's Inn to go to, and the treasurer at the time came from London for that dinner. We've had a wine and cheese night in Newcastle, but beyond that, not a massive amount has happened. Once I got that role, I was also allocated the job of sifting through scholarship applications. So that is linked to that, and that involves a little bit more work. But I'm really just the link. It doesn't involve great deal of work. I think Lincoln's Inn perhaps would say it should involve more work on my part, but it's very difficult to get people on circuit to commit to an in event when they've got circuit events, James events, and their own practice to look after. So it has been harder, in fact, than I thought to motivate people for Lincoln's Inn matters on circuit.
Absolutely. And in terms of them, when you're sifting through scholarship applications and things like that, are you excited for the future of the bar from what you're seeing in those applications? Are you impressed?
Very impressed. It's incredible how qualified people are, how strong they are academically, how much work experience they've done, many pupilages, and sitting in with judges, and all the charity work they've often done. It's credit to all these young people that they've fitted so much in and got such good degrees at the end of it. So it just makes me realize if I was applying now, I probably wouldn't get through.
A lot of people say, a lot of people say that.
Yes, their exam grades were certainly a lot better than mine.
Oh, that's really nice to hear and positive to hear that you're noticing some up and coming very good.
Completely.
Oh, that's amazing. Well, everyone shouldn't lose hope, and we'll all become barristers.
No, quite right.
So then in the murder trials then, thank you so much also for joining me this evening. I seen your LinkedIn, I stalked Park Square Chambers, and I also stalked you on Google as well, and I was like, I need to get Mark on my podcast, so thank you so much for agreeing to it.
No, I hope I don't under deliver.
No, I doubt it. And of course, murder trials as well. It's the first podcast episode I've had on something like this. So thank you, and obviously your experience. I just thought it would be a perfect guest to host. So the legal process and the strategy of the trials. Then, for those who don't know, what are the key elements that the prosecution have to bring in a murder trial?
Well, we're working on the basis that there's just one defendant at the moment. Obviously, it becomes complicated if more than one person is charged, but firstly, the prosecution have to prove the defendant caused the death. Secondly, that it was caused unlawfully, so, for example, not in self-defense. And then thirdly, that the defendant either intended to kill the deceased or intended to cause really serious harm. And I think a lot of people, perhaps even jurors, are surprised to hear that the prosecution don't need to prove an intention to kill. And realistically, in many cases, unless there's a shooting or something very dramatic, it's a lot easier to prove an intention to cause really serious harm than to prove an intention to kill. And conversely, if somebody's charged with attempted murder, the prosecution have to prove an intention to kill. But with murder itself, the intent is lower than an intention to kill. So those are the main elements. And obviously, the issues can be very different from one case to the next.
Do you think then, on just the face of it, prosecuting is harder, more difficult than defending, or do you think defending is more, and just working on that it's just one person, one defendant, not multiple?
It depends on the case really, and what the issues are. Prosecution involves preparation well in advance of the trial, because you've got to do an opening where you summarize the evidence and the issues in the case, and prepare and order of witnesses and decide what goes in the jury bundle. And then when you're defending, you're really reacting to the work which the prosecutor has done. Thereafter, it really will depend on what the issues are. I think if there's a complicated medical issue, for example, that requires pathologists on both sides or a neuropathologist, that's when it can become more difficult to defend, to try and score some useful points from the prosecution. Pathologist can often be very difficult, although you would have your own expert to help you with what areas you ought to explore and what areas you ought to leave alone. But it's difficult to answer for a single defendant. It depends on the case. When there are a lot of defendants, it's very much harder to prosecute, because you're working at it all the time, and each defence counsel will become involved every so often as their defendant features. But it's still nice to have that feeling of being in control of the case when you are prosecuting.
And then that same question, but in terms of attempted murder, because like you just mentioned there, the element for attempted murder is to actually the prosecution have to prove that the intention was to kill them. Do you think that's quite a difficult thing to prosecute? And I know I've spoken to other previous barristers, and they said that sometimes attempted murder cases are a bit more gruesome, so the evidence might be a little bit stronger. But what's your take?
Again, it depends on the evidence in the case. The main point the defence always take in an attempted murder case is if the defendant really intended to kill the victim, what was there to stop them? If they had a knife and they were still alive, why didn't they stab them one more time? They had a gun and they were still alive, why didn't they shoot them one more time? Why didn't they kick them one more time? But really, it all depends on the number of blows and the type of blows, type of weapon used, and often what a defendant has said before, during, or after. So sometimes you will get somebody literally saying they want to kill someone. Of course, defense will say, take that with a pinch of salt. That's the sort of thing anyone can say, but it's often not just what a person has done, but what they've said as well. But really, when you're prosecuting an attempted murder, you've got the safety blanket of either causing grievous bodily harm or wounding with intent as an alternative. So, unless the issue is identification or something like that, then you're likely to at least get a conviction for a very serious offence, even if it's not for attempted murder. So that takes the pressure off to some extent.
Yeah, absolutely. So then what would you say the first steps, or what do you do in terms of your first steps when constructing a defence where the evidence can be overwhelming?
Well, obviously, if the evidence really is overwhelming, then we'd have a duty to speak to the defendant about whether they should be pleading guilty to murder or offering a guilty plea to manslaughter. Unfortunately, the discount for plea in murder is half what it is in other cases, so a maximum of 1/6. So it's not very attractive to a defendant to plead guilty. But really, how to approach a defence is dependent upon what the defence is. Clearly, the defence has to come from the defendant and not from the barrister. They have to say whether they were acting in self-defence or whether it must have been someone else other than them. We have to be very careful not to suggest what defence would be best for them. Although, of course, a defence barrister can always test the evidence and see if the elements of the offence are proved. I could always cross-examine the prosecution pathologist about the cause of death and whether there are any alternatives, including, of course, natural causes, particularly if somebody is old and that they've had a heart attack or stroke during the course of what has happened. But really, if there is a possibility that the deceased has died of natural causes or possibly already injured before the defendant used violence, I think the key there is to seek the help of a defence expert, a pathologist or a neuropathologist, and ask them what parts of the prosecution evidence can be challenged, and to get them to suggest questions which they know the prosecution pathologist will have to agree with. So really, my main advice is to get help from an expert where the prosecution are relying on any expert evidence. If the defence is self-defence, for example, I'd want to be looking at the unused material to see if there are any witnesses who've seen the deceased behaving aggressively at the time or in the past, applied to put in evidence any previous convictions for violence which the deceased has got. In some cases, it can feel a bit like clutching at straws or muddying the waters, but some cases they may be the only points you can find, but they're points the defendant is entitled to, and if we can find them, then we would put those points forward. But it very much depends on what the issues in the case are.
Absolutely, thank you so much for that and for telling us all that. So then, in terms of what you just said there about how sometimes you might be advising the defendant to consider putting in a guilty plea for manslaughter, how often have you seen personally cases go from murder on the indictment down to manslaughter, whether that be through a plea or whether that be through the prosecution?
Obviously, it's open to the prosecution to only charge murder in the first place, For example, if there was a single punch that caused somebody to bang their head, although I have seen people convicted of murder for a single punch when it's been a really hard punch. Sometimes the prosecution will accept a guilty plea to manslaughter as other evidence comes in and perhaps unused material starts to undermine the behaviour of the deceased. But usually, if the prosecution have charged murder, they're unlikely to back down on that. They'd rather leave it to a jury, who of course have got the choice of murder or manslaughter or not guilty, rather than the prosecution having to take the responsibility of accepting lesser plea. What's perhaps more realistic is if a number of people are charged with murder and the person who was most involved and caused the death offers to plead guilty to murder, then the prosecution might take manslaughter from those less involved in those circumstances. But of course, we've got three specific areas where murder can become manslaughter, and that the jury would have that alternative. The obvious one is where there's no intention to kill or to cause really serious harm. That would be manslaughter rather than murder. The next one is diminished responsibility. That is where someone has a mental illness, or as it's called, an abnormality of mental functioning, which has substantially impaired their judgment, essentially, or their understanding of what they're doing, or their ability to exercise self-control. And I think that defence, or partial defence as it's called, converting murder to manslaughter, is perhaps the one most likely to succeed, because it's likely to be supported by expert evidence. You'd normally have a psychiatrist who would support that. Although if you've got psychiatrists on both sides who disagree, that's one of the few areas in the criminal law where the burden is upon the defendant to establish diminished responsibility, albeit on the balance of probabilities. And the other one is loss of control. So if you've got somebody in the defendant's circumstances who, with a normal degree of tolerance, might have acted in a way in which the defendant did, then the jury are entitled to convict of manslaughter rather than murder. Now, again, that's often got a reasonable chance of succeeding if it's left to the jury, because the judge has a filtering job, and he would only leave that defence to the jury if there was proper evidence of a qualifying trigger for that. But those are the options. Bad news often for somebody convicted of manslaughter on the grounds of diminished responsibility, that is traditionally thought to be a bad place to be in when it comes to going before the parole board. If you've been able to kill someone and not have full moral and legal responsibility for it, some people might think it could make it more likely you would do it again. So it's not always a perfect outcome.
And off the back of that, you did a case. I think you were involved in a case with diminished responsibility. I think I saw on Chambers' website, somebody had killed their friend, and I think that involved some expert witnesses and some complicated issues in that case. Do you often do a lot of cases where diminished responsibility crops up?
I've done two recently. Yes, what one involved killing a friend. In fact, I was prosecuting that one. The defense psychiatrist didn't support diminished responsibility, but a psychologist did. So really, from a jury's point of view, the prosecution had a psychiatrist versus a psychologist, which was always going to help the prosecution. But that this was a case where the defendant had behaved around the time in quite a rational way. They'd had an argument over something ordinary, and then he'd walked a long distance to the supermarket to buy a packet of knives and then walked back. So he'd had a lot of thinking time, a lot of time where he was behaving calmly. So I can understand why the jury rejected diminished responsibility there.
Yeah.
I had one defence case as well where the jury rejected diminished responsibility. The jury knew the defendant had killed 2 people in the past and then been released, and he became an alcoholic again, and he'd killed someone soon after he'd been released, and he was relying on alcohol abstinence syndrome. So I had to say to the jury, the defendant is not saying that he carried out this killing because he was drunk. He was carrying out this killing because he wasn't drunk. He was so desperate for alcohol that his thought processes were not functioning properly. He was concentrating only on where his next alcohol would come from, and not on the amount of harm that he would cause. But again, that had competing psychiatrists. If both psychiatrists had agreed that syndrome had played a significant part in what he did, then I think the jury would have accepted it. When the psychiatrists disagree, that they're more likely to side with the prosecution in those circumstances, particularly when they knew that he'd got 2 convictions for murder where diminished responsibility had not applied there.
Okay, well, thank you. That's very interesting. Yeah, I read the one about the case where he went to the supermarket, and yeah, I read that. That's what I was referring to, Asda, I think it was, wasn't it?
It was, yeah, no, that very sad case in Harrogate, I think it was.
Yeah, it was awful. Yeah, I read that, and I can also understand why diminished responsibility wasn't accepted there, because if you're walking all the way that distance to go and get something.
Yes.
When would you advise your client not to give evidence, and why would you advise that? And
well, always a difficult question. Of course, I always advise a defendant that it is his choice whether to give evidence or not, and there isn't any point in giving evidence if they've got no explanation for the prosecution case. But at the very least, a defendant's able to tell the jury that he didn't intend to cause really serious harm, and that the consequences gone a lot further than he had wanted. In fact, rightly or wrongly, and my London colleagues would be horrified to hear me say this, I've never not called my defendant in a murder case. I've always called them to give evidence. And that's just how it's been. We've discussed the pros and cons, and I usually make this point that if I was on trial for murder and I had a defence, I would want the jury to know my side of things. And another practical problem is, in most murder cases, the defendant's made no comment in interview. So if he doesn't give evidence, there's no explanation for the jury to consider. And also, there's the legal direction that the jury can use his silence as some support for the prosecution case. And I found that in other cases where a defendant's not given evidence in a murder case, then they tend to be convicted. The jury expect to hear an explanation as to why they are not guilty of murder. But it's surprising how common it is for defendants not to give evidence in murder cases. But equally, many defendants who do give evidence, it becomes apparent quite soon that they haven't really got a proper explanation for what they've done. So it may be in a no-win situation in many cases.
Yeah, absolutely. So thank you very much. And so in terms of the emotional side of things, you said that quite luckily you've never really had that emotional impact from cases. Of course, you would have felt like, you know, sympathy for both sides and things, but you haven't been struck by it. Have you ever done well, what is the most morally challenging murder that you have worked on?
I haven't found any murder really morally challenging. I'm always very careful to make sure it's done within the rules. So the defendant tells me what his defence is, and no matter how fanciful that might be, then it's my duty to advance that defence. And even if I think that it's got no prospect of success, there's nothing morally challenging about having to pursue that defence. I had one case recently where someone put on a mask, armed themselves with a knife, broke into a house, and his case was that he then stabbed the home owner 10 times in self-defense. That realistically wasn't going to be successful, but I had to advance that, and just because the defendant had a mask, a knife, and he'd gone into somebody else's home doesn't mean, as a matter of law or logic, that he didn't become under attack at some point and have to try and defend himself. So it feels morally awkward in a way that you're advancing a defence like that, but it has to be done. That's our duty. The defendant could have pleaded guilty, but when he insisted he was not guilty, then we had to do our best, and including calling him to give evidence to explain his side of things.
Yeah, absolutely, of course. So then, what would you say some of the most effective cross-examination techniques are in a murder trial, on both the prosecution side and the defence?
When prosecuting and cross-examining a defendant, my main tactic is to ask open questions. I know a lot of my colleagues would disagree with this. I've done some advocacy training, and advocacy trainers are horrified by this. They say that cross-examination should be leading and controlled, so you're in charge of what the witness says. But just to give an example that I often give to students, say in a stabbing case, I could ask the leading question: when you stabbed the deceased 10 inches into his chest, did you intend to cause him really serious harm? I know the answer is going to be no, because they've pleaded not guilty to murder.
Mm-hmm.
So I've achieved nothing with that question other than putting my case. But if I put it more openly and say, when you stabbed the deceased 10 inches deep into his chest, what did you intend to happen to him? Then the onus is upon the defendant to actually explain himself then. If he's got an explanation, he can't just say no. He's got to explain what was in his mind at the time. And if he says something silly, like, well, I thought it'd just cause a small cut and he could have put a plaster on it and gone to work the next day, the defendant's going to sound ridiculous giving that explanation. So I think that's my main point really when prosecuting. And another point that I think helps the prosecution a lot in a multi-handed case is to ask one defendant what the other defendants did in turn. they don't like that. They become awkward and argumentative, and they tell lies, and obvious lies, to protect their friends. That discredits them as a witness in their own case, but also highlights the fact that they were all in this attack together, that even after someone has died and even after they're on trial for murder, they're still protecting each other and acting as a team. Prosecuting or defending, I've touched upon this already. When you've got an expert witness to cross-examine, don't try and pretend you're an expert yourself as a barrister. Instruct an expert to look at the prosecution expert's report and to look at areas where there can be successful challenge. When I've got to cross-examine a neuropathologist, I literally send my questions to a defense neuropathologist, and he goes through them and he crosses some out, changes the wording of some of them, and then when I cross-examine the neuropathologist, he will agree with all my points, and it looks as if I understand neuropathology, which is almost impossible to understand. But it's because the expert has given me the guidance. I suppose my job to some extent is to ask the right questions of my expert, but that I think is very important, be guided by an expert. And another little point that applies to all cases, but it's never done properly, or hardly ever done properly, is if you've got a previous inconsistent statement. Could be the interview or a witness statement. Just take a silly example. That you could say, do you agree today you said the gunman left in a blue car? Are you sure about the colour? Is it possible that you've made a mistake? The witness will say, yeah, definitely blue car. No possibility I've made a mistake. Would you have a look at your witness statement? Where many people go wrong is they tell the witness what's in the witness statement, and the witness will say, well, I can't remember, might be right, might not be right. Give the witness statement and ask them to confirm it's their witness statement. Ask them what they said to the police at the time about the colour of the car, and that might say, well, it was a white car that the murderer left in. Then you can ask which colour is correct. Can you explain why you've given two different colours? Are you sure now what colour car the gunman or knife man left in? But it's that point of no uncertainty, that there is that difference between the evidence and in the witness statement, because you're making the witness themselves give the alternative account that they gave to the police. But that really is underdone so many times by the witness not having in writing in front of them that inconsistency. But just a few random examples.
Yeah, thanks so much for that. Thank you very much. There's a few legal practical tips for us all to take there. So in terms of the strategy that you've just gave an example of there, and your approach to that and cross-examination in particular, your first murder trial as a KC, has your strategy changed from that first trial to now, do you think? Or do you think you've always kind of took that approach?
I don't think so. I suppose I've been doing trials for such a long time.
Of course.
Before my first murder trial.
Mm-hmm.
So I think that the strategy is the same, really. The key to it is preparing properly, working out what the real issues in the case are, what's relevant and what's important. Not everybody's been on the class where they're told that evidence is only admissible if it's relevant. And it really is important to focus on what's relevant. And I think just to look at what the main issues are, and to look for evidence and questions which can support your case in relation to those main issues. Ironically, the first murder case I did is probably still the most complicated case I've had to do, because two people had attacked the deceased at separate times, and the neuropathologist had to be cross-examined about which attack might have caused the brain injury that caused the deceased to die. Because, of course, if the deceased already had the fatal brain injury before the defendant I was representing became involved in any violence, that then he couldn't be guilty of murder or indeed manslaughter. So really, it was a from an expert evidence point of view, the most complicated case I'd done, and it had the awkward background where our defence really was, yes, I've been kicking the deceased in the head, but will you let me off murder or manslaughter, because somebody else might have caused the brain injury, which is not an attractive combination, but you have to persuade the jury to be disciplined and do it fairly.
Absolutely. What was the outcome?
It did not go in my favour.
Oh.
Yes, no, the jury convicted in that case. In fact, they convicted both people of murder who'd been kicking the deceased, even though that there was, I thought, quite good evidence that the attacks were not connected. The defendants didn't seem to know each other, and there was quite a gap in time between the violence they'd both used. But the jury must have accepted that this was, to some extent, a joint attack.
Oh, okay. Well, that's interesting. I can imagine. Yeah, even though it's, one of them would have had to cause the fatality, it's interesting that the jury still returned two guilty verdicts for both of them.
Yes.
So in terms of then the joint enterprise side of things,
yes,
joint enterprise, I did my dissertation on, because
right.
When I was a criminal paralegal, I worked on a joint enterprise case.
Yes.
Happened in London, and it was a gang affiliation that ended up becoming two gangs seeing each other and stabbed basically the other gang. But there was like 6-7 co-defendants, and I really became so interested in joint enterprise as a legal doctrine, and I did a lot of research about it and read all of the cases and things. And a lot of people actually in my position as aspiring barristers, believe it or not, don't actually know about joint enterprise, and they don't really understand what it's all about. So obviously I've read a lot about how it's a bit of a controversial point at the moment. People are saying that it's getting overused and it's not getting used in the right way and things like that. And what's your take on joint enterprise? Obviously it's good in some cases, of course it is, but do you think there can be a bit of a dangerous territory with it?
Well, I think as a starting point, you need to bear in mind that it was decided generations ago that you can be guilty of murder with only an intention to cause really serious harm. So that applies whether you are the person who has carried out the killing, or the person who's a joint party to that. So you need to bear in mind, when we consider fairness, that you still can only be convicted of murder if you intended that the deceased suffered at least really serious harm. So you've got to have that intention, whether you've struck the fatal blow or somebody else has, to be convicted of murder. You have still got to have intended that the victim suffered really serious harm, and that you played some part in that. But just to really put it into context, obviously to be guilty of murder or manslaughter, you can either cause the death yourself, so the person with the knife in the example you've given us, Ellie, and that would be what lawyers call the principal, the person who's actually caused the death. You would also be guilty of murder or manslaughter if you deliberately helped or encouraged the principal, and those who've helped or encouraged the what we call secondary parties. So, for example, a person who chases a deceased and brings him to the ground so that somebody else could stab him would be an easy example of a secondary party, although that would fall under the heading of helping. What is perhaps less black and white is when you're under the label of deliberately encouraging the principal to carry out the stabbing, and the encouraging doesn't really come from somebody saying please go and stab him. It comes from a joint attack and the logic that if four people are attacking the same person, they're all encouraging each other to be a party to that attack. But again, I come back to the point I made at the start. If you're only, in inverted commas, helping or encouraging the principal to use violence towards the deceased, you still have to have that intention that the deceased be killed or be caused really serious harm. So a lot of people will say it's unfair, this defendant was convicted of murder, he was just standing there watching or just running with the group and not doing anything. The jury must have found as a fact, they were sure that he had at least deliberately encouraged the principal to attack the deceased with an intention that he's caused really serious harm. So in other words, you can't get conviction for murder on a trivial basis. But I think that the point really right at the heart of all this, to take your example where you've got 6 people, only one doing the stabbing. I think if you'd got all of those people attacking the deceased at the same time, and one produced a knife, let's say the others didn't know about the knife, and killed the deceased, the parents of the deceased would all think that the group were equally to blame, and none of this would have happened had they not all played their part. On the other hand, the parents of the 5 or 6 who had not done the stabbing would think that it was very harsh that their son had been convicted of murder. And I think in terms of where the law is controversial and where you could have a difference of political opinion is whether the prosecution have to prove that the other people helped or encouraged the principal to actually use the knife, in other words, to use the murder weapon. But if that was the case, then you'd be inviting not guilty verdicts for people who were literally stamping on the head of the deceased, intending to fracture his skull and intending that he be caused really serious harm. They'd be entitled to be found not guilty just because the method of death was slightly different to what they were doing. So that I think is where the controversy comes, whether we should change the law to make people be an actual secondary party to the precise method of death.
Yeah, I think some of the articles and arguments that I read when MPs were raising these concerns was there needs to be a proper definition of what is significant contribution of the aiding, abetting, assisting, and encouraging, and what actually amounts to that significant contribution. I think it was an MP in Liverpool, Kim, I think her name was, I've forgotten what her surname was, but I read
Yes.
it a while ago. But that case that you're talking about, what you've just done there is provided clarity to me, because I think the reason why I was shocked about that case was it was a lot of complicated issues involving drill lyrics and gangs and things like that. But in fact, there was three or four of them. The prosecution couldn't actually pinpoint how many, because where the murder happened, there was no CCTV. But there was definitely three or four of them based off of witness statements that actually stabbed the victim, the deceased, and they all actively ran in a group. So that's just, you've just made clear to me exactly why the jury returned a guilty verdict for all of them, because even though they are just running, they all had knives on them as well. So it's not as if one just produced a knife in the spur of the moment. They all did have knives. And they all waved the knives previously, a couple of moments before the murder on CCTV, and then obviously there's three or four of them that committed the murder. So,
but I've heard pressure groups using the phrase significant contribution and asking for that to be added to the law, and obviously whether that happens is more a matter for politicians rather than lawyers. But seems to me that if the jury are sure that you deliberately encouraged someone to cause at least really serious harm, how could that not be a significant contribution anyway?
absolutely. And like you said, it's about encouraging, isn't it? If you're all sat there running across in the same direction and you know what's going to, even if you don't know what's going to happen, but you know somebody's going to get really harmed, well, then you know, you are already playing a part in that. And yeah, I can see both sides of it. I agree with you, but that's definitely made it clear. So.
But there is something just to complicate it further, which I looked up actually, so we don't come across it very often. But it's something called overwhelming supervening event. I don't know if you've heard of that, but to take the example that we have just given of only one person using the knife during a joint attack, if that person, instead of using the knife, had actually left and come back in a stolen bus and run the victim over, then there'd be an obvious gap or break in causation between what the group had done and what the person causing the death had done. But rightly or wrongly, the Court of Appeal have interpreted the overwhelming supervening event very narrowly. So it's a defence that rarely succeeds. And as a matter of policy, it seems to be that if there's a group attack with fists and feet and somebody produces a knife, that doesn't break the chain of causation. So the test is, did you deliberately encourage the knife man to use violence? Did you intend that at least really serious harm be caused? And if the answer to both of those questions is yes, it doesn't actually matter that you didn't realize a knife was going to be produced. That again sort of highlights the arguments on both sides as to whether that's controversial or not.
Oh wow, that's really interesting. Thank you so much for it. And I'll read up a little bit more about that actually as well. In terms of then a lot of the cases that you've worked on that have complicated joint enterprise issues involving youth offenders and things like that, there seems to be, and I know you did one in, I think it was Northumberland, where a young boy sadly lost his life from a knife attack as well. And it does seem to be a lot of knives getting used from the younger generation, isn't it? Do you think that that's becoming a real problem in the country at the moment?
It is clearly a problem. Most of our murder cases involve knives. I think in the northeast there are far fewer guns than we get in other areas anyway. So we're fortunate. So it tends to be a knife that is used. But I've often cross-examined young boys, 14 or 15. I'll say, Johnny, when you went out that night, why on earth did you take a knife with you? And they look at me as if I've gone mad, as if to say, well, doesn't everyone carry a knife? That perhaps I'm in a difficult position because I've used it, but to actually carry a knife is seen as perfectly normal. I had someone say to me, do you appreciate where I live? If I didn't carry a knife, I'd be the only person in the street who hadn't got one, and that would make me vulnerable. And if that's very sad, if it's accurate or even thought to be accurate.
Absolutely. A podcast I did previous couple podcast episodes before yourself this evening was with a barrister called Stephen Akinsanya from London, and he's an advocate at the moment for knife crime. And he said exactly what you've just said there. So many of them are carrying knives to protect themselves because of the area that they're in. And Stephen said the same thing that you said. If that's where we're at as a country, then that's a really sad state of affairs to be in.
And I suppose going back to the joint enterprise point, or joint participation, as we're supposed to call it now after the Joji case, more young people are likely to be convicted of murder, because if you've got a large group of 5 or 6 who are attacking someone else, the chances of one of these young people actually having a knife is quite high now. So that's perhaps why a lot of young people are convicted on a joint enterprise basis, because somebody in their group sadly has a knife which causes a fatal injury.
Absolutely. And what do you think the main challenges are in defending a young person charged with murder under the legal doctrine of joint enterprise, where they haven't delivered that, where they haven't delivered a law?
Well, I think you'd get conflicting views on this, but my view is that the age of a defendant is most likely to be a positive point for the defence rather than a negative point. I think that a jury would be looking for the opportunity to find a young person not guilty if they could, or at least to reduce murder to manslaughter, and to say they weren't sure about the intent if they could. And I really don't think you would get a jury convicting a 14 or 15-year-old of murder as a secondary party unless they really were sure that the elements were made out. It should apply in every case, whatever the age of the defendant. But I don't think there's a logic in a jury that because these people are young, that they're more likely to be guilty than had the group carrying out the attack been older. I suppose you've got the slight risk of pack mentality, but I think a jury look fairly at what each individual has done, rather than treating them all in the same way.
Absolutely. And where you've just said there about the age and things like that, one of the questions was, how the age and maturity of a young defendant influences the way joint enterprise is argued in court. You've just said there, the jury wouldn't bring back a verdict guilty if they didn't believe that all the elements were met, especially when these boys and girls are so young as well. For them to be, found guilty of murder, they must have had some sort of contribution. And I think social media and like the generation that we're all kind of living in at the moment probably plays a big part. Do you agree, with young kids going out and doing things and they're just so violent? Like even, I went for a walk this evening and they're like, throwing bottles of Coke like off of each other's heads and things, and I'm just like, stay away from me.
There's obviously the risk that jurors have been fed up with antisocial behaviour from young people, but I think in most city centres now it's not just young people, it's older people as well. And I really think in a murder case the jury would put that to one side and to say we can't just tar all these people with the same brush. We've got to look precisely at what each defendant did, what each defendant said. It's not enough that they were just there not enough that they've just run in the same direction as the knife man. There must be positive evidence that we can be sure that they were deliberately encouraging this violence and intended there to be a death or really serious harm. So it's still a high bar the prosecution have got to get over.
Absolutely. So on the basis, on a whole, then, do you think that joint enterprise is getting applied fairly, and the current framework is in quite a good position? Of course, there's room for improvement in everything in life, but on a whole.
I think whether joint enterprise should be changed is very much a political decision rather than a legal decision. Although when someone says that only Parliament can change the law on joint enterprise, that the famous case of Joji, which involved the House of Lords or the Supreme Court, as it's now called, it in some ways very much felt like the courts changing the law on joint enterprise rather than Parliament doing it, or that their answer to that is that they're just clarifying what the law is or should have been all along. But I think certainly that as far as I can tell, Parliament has no appetite for diluting the ingredients of murder. It will never be the case, I'm sure, that an intention to cause really serious harm is taken away as being enough. And I think that the test of deliberately encouraging or helping with the requirement of an intent to cause at least really serious harm provides very significant safeguards and means that somebody can only be convicted of murder if they've done something very bad. And I think Parliament's will, and probably society's will, is to keep it like that. Although I do see it from the point of view of someone whose son has been convicted of murder when they've not actually carried out the killing themselves.
I think it's about spreading more awareness, isn't it, about what young people are getting themselves involved in, and it's capturing it from an early stage, but that's a way bigger.
Well, it is. I mean, one thing that must be true is that many young people who've not carried out the stabbing themselves will be quite surprised when they realise how the prosecution can prove a murder against them. That they would automatically assume that there's only one person guilty of murder and that their kicking in the head didn't cause any serious injuries. So why would they be guilty of murder? Where of course that kicking in the head is the ultimate encouragement for the knife man and the ultimate evidence that supports an intention to cause really serious harm.
Absolutely. Well, Mark, I have like a million more questions to ask you, but I'm conscious of the time, and I did promise an hour, but unfortunately it's not always an hour. But there's a couple of questions that's been popped into the chat, and I would just like to
right, yeah, no, please do from my point of view.
Yeah, thank you so much, just so that Elishma gets the opportunity to have her questions answered. So the first one is, how do you bounce back from not obtaining the result that you were instructed to obtain?
Well, I don't think it's a question of bouncing back. I think that to do this job, and particularly murder cases, you have to be able to put your hand on your heart and say, I have done my absolute best for this case. I've left no stone unturned. I've rewritten my speech 100 times, and it couldn't be any better. But equally, it can only address the evidence that you've got. So I think, providing I've done my absolute best, then I can't beat myself up about the outcome. Otherwise, the job would become unbearable. And it's obviously much more difficult if you think you have got a reasonable chance, at least, of this being called a manslaughter rather than murder, and it doesn't happen. But you just have to respect the fact that it's trial by jury, and there are two sides to most points. But really, you just have to live with it and accept it as part of the job, and ultimately you are entitled to say, it seems to me, that that's not my fault. Did my best. The conviction was down to the evidence rather than the barristers ultimately.
Absolutely. Thank you very much. Next question is, you mentioned that when prosecuting multi-handed cases, they can be difficult. How do you manage your workload when you've got so much to already focus on? And also, how do you communicate with defence counsel as a prosecuting counsel effectively prior to the hearings?
I very keen on preparation in advance. So as soon as I was briefed in a murder case, I'd read it as soon as I could. I'd take it with me to court when I was doing other cases and just read it and prepare it up front, so that when the trial itself is going on, I've already written my closing speech and my cross-examination of the defendants, partly because I won't have enough time to do that job when it comes to it, but also because it gives me a better focus on the issues in the case and what I'm looking for. In particular, when you've written down a good point in your closing speech, you want to make sure that you don't lose that as a result of that point not coming out in evidence. So that helps to have prepared it in advance. But I'm very keen on communicating with defence counsel. Fortunately, on our computer system, you have the email now of all defence counsels. So I will send them my email address and phone number and copy them into any documents I've been drafting, and it involve them at an early stage and ask them if there are any ways in which I can help them, because sometimes it's easier for me with an overview of the whole case to find things that the defence might need. I'm perfectly happy to help them find things they're entitled to, and to see what we can agree and not agree. So in particular, it's very embarrassing when you bring a witness to court and nobody's got any questions for them. So you need to really check what's agreed and what's in dispute beforehand. So some barristers, of course, have fallen out long before they get to court. In that case, or in previous cases, I've never really had that, fortunately, and I'd much rather have a good working relationship with defence counsel. So normally defence counsel will cooperate. It doesn't happen very often. You have to be careful sometimes to spot when someone's trying to get a concession from you in the robing room that they'll hold you to in court, and just not in a improper way at all, but just be on your guard really as to why you're having a particular discussion. But nearly everybody in this job approaches it in good faith and with a spirit of cooperation. Just wants to ultimately, our job's about making it easier for the jury to follow and to make the right decisions.
Thank you for dispelling probably a misconception that a lot of people have, that not the other sides are all monsters with each other, and that actually people do get along.
There are exceptions, I know, and I think the Northeastern Circuit has always had a good reputation for people getting on with each other.
Yeah, fantastic. Well, that's definitely reassuring to everybody, I'm sure, who wants to practice in the Northeast. Next question is, has always calling your client to give evidence worked in your favour? Always worked in your favour?
I'm sure it hasn't. But ultimately, whether it's made a difference I can't really say because I've no way of knowing what the verdict would have been had I not called them. But I've called many defendants to give evidence who have been positively horrible and unpleasant in the witness box, that they've been awkward, argumentative, and the prosecution have scored lots of points from them. But ultimately, they're still able to say, I am not guilty of murder. And I've looked you, the jury, in the eye and told you I'm not guilty of murder. You don't have to like me. I've done some unpleasant things. I might not be very polite in court, but I've given evidence because I'm innocent. And whether that's better or worse than the direction that not giving evidence can be some support for the prosecution case is just impossible to judge. It is a question of degree. Some defendants have been so bad that obviously I've thought I wish this defendant hadn't given evidence, but equally, I don't think it's my place to talk them out of giving evidence if they've got an innocent account to give. It's fine to say it's your choice, and you might not be very good at giving evidence for the following reasons, but ultimately I very much believe it should be their choice, and I wouldn't like to put pressure on them not to.
Absolutely. Yeah, it's kind of like their last, could be their last, well, not hurrah, but last.
Absolutely, yes.
I would want to if I was innocent, definitely. And then last question is, you talked about advocacy training. How much of that do you receive throughout of your career as a barrister, and who delivers it? So is it usually advocacy trainers on the circuit and the Inn of Court?
Yes, I think the circuit and inns really coordinate the advocacy training now. So I know that new practitioners get advocacy training, which is done locally, so you don't have to go to London for it if you're in Leeds. Then there's further advocacy training, I think, for people of about 2 years call. That the best training, I think, is teaching you to cross-examine vulnerable witnesses. That I think was a godsend for me, and you learn the basics really just through cross-examining a young child. It's probably stating the obvious, but we've all fallen into the traps of doing it wrong. Things such as make sure your question is a question and not a statement. Only ask one question at once. Ask the questions in chronological order. Put the questions under headings so there's a structure to it. And I thought the vulnerable witness training was a godsend to me. When I started, we didn't get any of this training at all. I think we had about an hour at bar school on cross-examination, and then you learnt on the job through your pupil supervisor and seeing other people in court. So it's still a relatively new concept, the advocacy training, but it is very good. I've been very impressed with some of the people who do that.
It's fantastic, and thank you so much for that. Well, Mark, have you got anything you'd like to say, or anything you'd like to finish the podcast episode on, or anything you'd like to add?
No, only to encourage anybody who's watching the podcast to come to the bar. I've been doing it a long time, and I can't think of a better job. You have good days and bad days, but it's a great job to do. I think providing you're prepared for hard work, and it's one of the best jobs in the world. So please don't be put off as well when people apply for pupillage and don't get it the first time. I know people who've had no interviews 1 year and then got pupillage at the one of the best chambers in the country the year afterwards, and the reason you don't get it is just because there are so many good candidates, and if you keep trying and particularly if you're watching podcasts like this as well, it's good training, and you will get there. So thank you to anybody who's watched the podcast, and good luck in the future.
Thank you so much, Mark, and you just had a thank you very much for answering the girls' questions in the chat as well. They've just sent you a thank you. I'll upload this onto YouTube as well, if that's okay with you. And I just want to say thank you ever so much, a real heartfelt thank you so much for joining me this evening, and thanks so much for your time as well, and everything you've told me has been fantastic.
No, well, thank you, Ellen. Congratulations to you for running this podcast. It must be great for the students who follow it. So I wish you luck with your career in the future.
Thank you ever so much, Mark. Thank you ever so much for your time again as well. And hopefully I'll meet you one day as well.
No, I do hope so. Thank you again, Ali. Appreciate it. Thank you, everybody. All the best. Bye now.
Bye. Thank you so much, Mark.
Thanks, Ellie. I think I pressed leave now.
Yeah.